The judgment that was just delivered last 6th of September in the Presidential Tribunal, the Court of Appeal, actually it came as a surprise, not only to myself, but to all and sundry, all Nigerians.
Hello guys, you are welcome back to this channel where we dey bring una all the latest news where they happen for Naija. So guys, this legal advisor actually came out and revealed lot of things to Nigerians about the just concluded judgment. I want you guys to listen to this man and pay attention. Don't forget to share this video and give this video a thumbs up.
I was disappointed because the court came out and the judges, they gave a judgment, but they did not render justice to the matter. So I can see that judgment as a judgment in error. We know that law is dynamic and is mutable. The law keep on developing, and the court, like in law, we say that whatever is the pronouncement of the court is what is the law. But then everybody looks up to the court as the last hope of the common man. It's a temple of justice. And even the judges who are the members of the bench, and even the lawyers who are equally members of the bar, we're all members of, we are all, in the temple of justice, we are ministers. But especially those of the judges, they are seen as they should be above board, because they are looked upon, as arbiters. And when they come out to give judgment, they should equally look at the facts of the matter, look at the evidence adduced, and then arrive at their judgment. And that's why most times when you see a judgment of a court, there are rules, there are things you need to identify, what we call the obiter. The obiter dictum is what actually informed the court to arrive at their decision, or the stare decisis. But these things we are lacking in that judgment, because looking at what I saw in the court that day, everybody says it. You saw there's issues that need to be addressed. When you talk about evidence, the court was even appearing as if they were aligning with the respondent, whether they were taking side. The way they reacted whenever there's an issue that concerns the respondent, they were there as if they were praising the respondents. But when it concerns the petitioners, which my party is one of them, PDP, they reacted vehemently, with anger, as if there was even one of the judges were saying, do we expect them, the court, to manufacture evidence? But I saw during the proceedings, there was overwhelming evidence that were tendered by my party and even the Labour Party, even concerning qualification. The respondent was not even qualified ab initio from what the evidence tendered by my own party, showing that the forgery, the certificate forgery that was there, even the matter is still pending in a court in America, showing that there was forfeiture, drug forfeiture, money laundering, that involved drug. And then I saw the court. The court supposed to be a court, like I say, a temple of justice. So they would have, even if they don't want to, rule on it, but they should have stood up to condemn that fact that somebody that is going to be a president of Nigeria would have had a case in court in America concerning or involving drug proceeds, and he was indicted and he forfeited that money. They were saying, like some of them were saying, it was not a criminal matter, whether civil or criminal. But at the end of the day, there was forfeiture. And in law, that's what we call plea bargain. When you forfeit something, you're trying to secure your freedom, and you had to forfeit something. The court would have risen up to condemn that particular act, even if at the end of the day. They're talking about transmission. I saw when the court was even saying that INEC has the right to transmit or collect results in any manner they want, which is not in order, because the Electoral Act was amended in 2022, and the innovation of that amendment of that act was that inclusion of electronic system of voting and transmission of results. And that was why the federal government spent billions of naira, even procuring. The INEC was giving so much money to procure the beavers machine. What would have been the essence of the need of bringing beavers? Because the beaver was to capture the voter, accredit the voter, and then capture that voter and the votes after the result has been collected. You capture the result and transmit it to the IRA of INEC. Then at the end of the day, INEC said that there was a glitch, they did not transmit. And that burden of proof should have rested upon them to prove beyond reasonable doubt why that glitch. So we expected the court, and even Nigerians expected that court to rise up and say, no, we must strengthen our democracy. And that democracy, why should we? Because the importance in the past, there was that, anomaly when we collect results manually. There were people who can manipulate the results, because if you collect it from the polling unit, before you get to either local government collection center or maybe finally to the total collection center, you will see that people can impugn some figures in there, just like what happened. We tendered documents, and even Labour Party tendered documents from INEC, that most of the result sheets were blurred, no figures were seen. Even the ones that were seen, they saw them tipexing them, there were tipex on them, like in Rivers State. These were things that happened and occurred, that took place in that election. We expected the court to condemn it, so that our younger generations who are coming up tomorrow, the future generation, can have confidence in both in INEC, both in the judicial system. Because if you don't do anything, you say the INEC has a right to transmit, you are finished, the Nigeria is finished. Then talk about that. You talk about the fact that